Hi, good evening, ladies and gentlemen. Today is our first lecture. Do you hear me, first of all?
Yes, sir.
Okay, right. So, we have 36 hours to complete this session and 2 hours. Each lecture contains 2 hours and 16 lessons. During this 36 hours, so 16 sessions, we are supposed to cover industrial law, law of contract, and agency law. Law of contract is very small and the agency law is very small. It's a less than 5% of the total lecture. Contract law, agency law is a one day session, 2 hours only. But contract law may be 3 sessions, but the rest, so out of 16, okay, 4, then another 12 devoted to industrial law. Industrial law, as far as the industrial law is concerned, I don't know why these people have mentioned it industrial law. It is actually employment law. There are more than 40 legislations as far as the employment law is concerned. But in day-to-day activities, we need to know the provisions of 16 legislations, 16 labor legislation. Industrial Dispute Act, Trade Union Ordinance, Soprano Peace Employees Act, Wages Boards Ordinance, 2005 Budgetary Relief Allowance of Workers Act, 2016 Budgetary Relief Allowance of Workers Act, and 2016 Minimum Wage Act, EPF Act, ETF Act, Gratuity Act, Termination of Employment of Workmen Act, Maternity Benefits Ordinance, Women, Young Persons and Children Act, Factories Ordinance, and Workmen Compensation Ordinance. These are the 16 legislations that we need to understand in day-to-day, as far as the day-to-day activities are concerned. But don't worry about it. I will let you, because, previously for this course, it was 24 into 3, how much? 54, no? Sorry, 24, 48, and 48, 62. 62 hours have been devoted to this. But unfortunately now, only 36 hours. We have 2-hour lectures and 16 sessions. So let me go through very quickly, because, I have not prepared, what do you call this? Syllabus, but I'm the one who, will prepare the question paper for you. So therefore, I will give you the exact knowledge and I will tell you what are the areas where I'm going to raise the questions for the examination. Okay. So today our first topic is the big topic is industrial law. Industrial law. That is the main area, right? Main topic. Industrial law. Under industrial law, first subject is, I'm Vimalavira, former Commissioner General of Labor, more than 25 years in the field of labor, including the Commissioner General. So you can raise any question because, okay, let me tell you, I know the subject because I was the practitioner. Okay, right. So number one, first topic is what is law and sources of law. This is very important. මොකද්ද නීතිය කියන්නේ? නීතියේ මූලාශ්‍ර මොනවද? What is law and sources of law? Hussein, right? Hussein, could you please switch off your microphone, not microphone, the camera? Hussein, okay, right. Camera, only camera, not microphone. What is law and sources of law? Do you hear me, first of all?
Yes, sir.
Sarindi?
Yes, sir.
Right. First topic, what is law and sources of law? Okay. These are the learning objectives. Ladies and gentlemen, these are the learning objectives. What are those? What are the learning objectives? You know, to understand what is law. Just give me 1 second. Okay, right. First subtopic, learning objectives. You have to know, take your note. Learning objectives. First bullet form, learning objectives, subtopic. To understand what is law. To understand what is law. Second bullet, to understand sources of law. Nitiya Mulastra. Okay, third bullet. Chintaka, you have to mute your microphone. Chintaka, you have to mute your microphone. Tarindi, you have to mute your microphone. I can't ask you repeatedly. You have to mute your microphone if you don't have any questions to be raised. Right? Okay. Third bullet, to know about court system in Sri Lanka. To know about court system in Sri Lanka. Next bullet. to learn about constitutional history. To learn about constitutional history. Next, the last bullet form or not least, basic understanding about personal laws in Sri Lanka. Okay, let me ask question, right? Sanjay, Kavinder, are you working in the private sector or government sector, or you are still studying?
I'm working in the private sector, sir.
Good, good. Then you have to, remember what I'm going to tell you. Madhusha, are you working or not? Taraka,
I'm working at a private sector.
okay, good. Right. Tarindi,
I am working, sir.
okay. In the private or public?
Private sector.
Good, good. I need people who work in the private sector, right? I love the people who work in the private sector, because the entire labor law, applicable to the private sector workers, but those are applicable to the semi-government sector as well, but mainly for the private sector. Chintaka,
Yes, sir.
are you working on?
Yeah, I am also working on private sector.
Good. Right. Nelunika, right? If I'm not mistaken. Yes. No, I can't hear you. Hussein?
So I'm having my own business, sir.
Yes, you are an employer, right?
Yeah.
This law is very important for you, right?
You can understand, yeah.
And Isuri?
I'm working at private sector, sir.
I'm really happy because, I'm not going to ask, one by one. So this is the group that there are around now 29 to 30 participants. Most of them are representing the private sector, right, as employers and employees. I'm really happy. This is, where we have very short period of time. Previously, for the business management, this series of lecture, labor law, industrial law, we had 24 sessions, 24 into 3 hours, 3-hour lectures. So imagine 24 into 3, how much? Right? 24 into 3.
72.
72. Unfortunately, we have only 36 hours. 1/3. Right? Okay, let me go very quickly. Because we have plenty to be covered. Okay, what is law? Ladies and gentlemen, the system of rules, law is the system of rules which a particular country or a community recognizes as regulating the action of its members and which it may impose by the imposition of punishment. Law is something like, recognized by the community. And if such laws are violated, then the person or the person who is violating the law can be punished. This is very simple way. And according to Wikipedia, law is a system of rules. System of rules created and imposed බලාත්මක කරනවා through governmental institution. නීතිය බලාත්මක කරන්න බෑ වෙන පුටපුද්ගලයෙකුට. Governmental institutions to regulate behavior හැසිරීම with its precise definition, a matter of long standing debate. මේ කියන කාරණය දිගු කාලීන ප්‍රශ්නයක්, debate එක. It has been variously described as a science and art of justice. Right. Take your note. Right. What is law? Another subtopic. Very quickly, very quickly, because we don't have time, much time. What is law? The system of rules. ඒක යටතේ ලියන්න. The system of rules which a particular country. මේවා කටපාඩම් කරන්න එපා, මේවා විභාගෙට ආන්නේ නැහැ. මේවා just for your understanding. The system of rules which a particular country or a community recognizes as regulating the action actions of its members and which it may be imposed by law. Violate කරොත් නීතියෙන් බලාත්මක කරන්න පුළුවන්. Imposed by the law, it may be imposed by the imposition of punishment. Imposition of the punishment. නීතිය මගින් බලාත්මක කළා දඬුවම් කරන්න පුළුවන්. Violate කරොත්. එහෙම එකක් තමයි නීතියක් කියන්නේ. Next para. Do you hear me? First of all.
Yes, sir.
Okay. Good.
Yes, sir. Yes.
Next para. Law is a system of rules. නීතිය කියන්නේ system කියන්නේ ඔබ දන්නවනේ ක්‍රමවේදයක්. Rules වල ක්‍රමවේදයක්. Law is a system of rules created and imposed through governmental institutions. එක එක්කෙනාට ඕන විදියට impose කරන්න බලාත්මක කරන්න බෑ. රාජ්‍ය ආයතනයක් විසින් ආයතන විසින් බලාත්මක කරන. මොකටද එහෙම බලාත්මක කරන්නේ? Through governmental institutions to regulate behavior. හැසිරීම් නියාමනය කරන්න. To regulate behavior. හැසිරීම් නියාමනය කරන්න. with its precise definition. A matter of long-standing debate. Make a debate එකට. එහෙම නැත්නම් විවාදයට බඳුන් වන කාරණයක්. A matter of long-standing debate. Right. It has been variously described. It has been variously described as science and art. As science and art. විද්‍යාව සහ කලාව. It has been variously described. ඒක මහා පළල් විදියට විස්තර කරනවා. මොකක් හැටියටද? As a science, විද්‍යාවක් හැටියට සහ art of justice. යුක්තියේ නැත්නම් justice සාධාරණත්වයේ එහෙම නැත්නම් justice යුක්තියේ කලාවක් හැටියට. Right. The continuation. Next bullet form. What is law? The continuation. A set of rules governed by the society or community. Law is a set of rules. Rules samudaya governed by the society. That's a community. Samaja mehevanu labana set of rules. First bullet. Not next bullet, a set of rules governed by the society. So could you please take your own note? First, next bullet, a set of rules governed by the society or community. Law is supreme in the society compared with customaries. Relating
Can't hear you now.
Taraka, you have to mute your microphone. Do you see the application? Do you see the presentation? Is it visible?
Still can't hear you, sir.
Isuri, do you see the presentation?
Yes, sir.
Do you hear me?
Yes, sir.
So, first bullet, under what is law, right? This is the first para, second para, and the third para. Or bullet, a set of rules governed by the society or community. That is law. Law is supreme in the society compared with customaries. Customaries කියන්නේ අපි අත්දැකීම් වලින් එහෙම නැත්නම් අපේ සමාජයේ තියෙන යම් පිළිගැනීම් customaries කියලා අපි කියන්නේ. Right? Practices ඒවට වඩා ඉහළින් තියෙන law එක. Right? Imposed by a formal institution. නීතිය බලාත්මක කරන්නේ කවුරු විසින්ද? Formal නිශ්චිත ආයතන විසින්. It's a social science. Law කියන්නේ සමාජ විද්‍යාවක්. Difficult to give common definition. Common definition එකක් දෙන්න අමාරුයි. So, ඔයාලා මේ ටික ලියා ගන්න ඕනේ. That is what I am saying. Once you finish it, let me know. අර කලින් කියපු topic එකම what is law කියන එක යටතේමයි. Once you finish this, let me know. මේක ඉවරුනහම මට කියන්න. ලියාගෙන ඉවරුනහම.
I'm finished, sir.
Okay. Everybody?
Yes, sir. We
Yes,
are done.
sir.
Yes,
We
sir.
are done.
Okay. Now, sources of law. These are very, very important. Nitiya Moolastra Manavada. Number one, legislations or statutes passed by the parliament. Right? Number two, case law. Case law means the decisions given by the higher courts. Number three, customary law. For example, customary law may be court decisions and statutes like Buddhist, right? Temporalities ordinance and customaries like Desavalame law. These are customaries. Right? And next, sources of law, textbooks and opinion of writers, religion, concept of equity, sadharana bhavi mooladharme, opinion of lawyers. These are actually the sources of law. But number one is the legislation or statutes passed by the parliament. The main sources of law is legislation or statutes passed by the parliament or legislature under the previous constitution. Under the previous constitution is legislature, right? Okay. Subtopic, sources of law. Nitiye Moolastra. Make a prasnekata hanuamai. There will be a question on this. What are the sources of law? You don't need to elaborate, but 1, 2, 3, 4, something like that. Number one, legislations or statutes. The legislations or statutes. This is these are the main sources of law. The main sources of law passed by the parliament or passed by the parliament or legislature. That is enough. Legislature means before independent we have, Rajya Mantrana Sabhava එක එක දේවල් තිබුණා. මම පස්සේ කියනවා. Now it is parliament. Okay? Right. Number two. Next. Number two. Case law. Stock. Decisions of the higher courts. Decisions of the higher court. I mean, appeal court and Supreme Court. Decisions of the higher court. You don't need to write all these things. Number three. Customary law. Customary කියන්නේ අපි මොකක්ද ඒකට සිංහලෙන් කියන්නේ? අපේ සංස්කෘතියත් එක්ක බැඳිච්ච දේවල්නේ. Even I don't remember the exact singular word, right? Customary law. Practices. සමාජයේ පිළිගත්තු දේවල්. Right. Number 4, 5, 6 and 7. You take the textbooks and opinion of writers, religion, concept of equity, opinion of lawyers. Take your note and let me know when you finish.
Finish, sir.
Okay, right. Next, look at court system or structure of Sri Lanka. Court system or court structure of Sri Lanka. Original courts, primary courts, not in existence today. Today, this is the primary, the first, the lowest court, magistrate court, district courts, high courts, commercial high courts. And we have appellate courts, provincial high courts. Under provincial high courts and civil appellate courts. This provincial high court has dual purpose. One is operating as provincial high court, and then as civil appellate courts, and then court of appeal and the Supreme Court. These are the court systems in Sri Lanka, ladies and gentlemen. Number lowest court, magistrate, then district court, high court, commercial high court, provincial high court, court of appeal, court of Supreme Court. So provincial high court has dual role, to act as provincial high court and to act as civil appellate courts. So that is why 1 and 2 is there, under provincial high court, because this provincial high court act as provincial high court and acts as civil appellate courts. So that is why it has dual role, the court. So now if I ask you to name court system or court structure in Sri Lanka from the lowest to highest, number one, lowest one is magistrate court, district court, high court, commercial high court, provincial high court, court of appeal, and Supreme Court. This is the structure. Do you understand? Do you understand, ladies and gentlemen?
Yes, sir.
Yes, sir.
Right. You take
Yes,
your or
sir.
not. You take your or not. ඔබම මේක ලියාගන්න මේ විදියට.
Finish, sir.
So we are done, sir.
Did you finish?
Yes, we are done.
Yes, sir.
Okay, now next subtopic is non-judicial dispute resolution bodies. These are judicial dispute. If there is a dispute, this is the judicial process. But with regard to disputes, there are non-judicial bodies as well. Human Rights Commission, Labor Tribunal is partial judiciary, Rent Board, Mediation Board, but however, you don't need to write these things, right? The constitutional history, then are moving to the constitutional history of Sri Lanka. I will be finishing this lecture within, 1.5 hours, first lecture, but later, sometimes it may go up to 2.5 hours as well, even though it is stick to 2 hours. So constitutional history. Okay. With regard to, the evolution of law in Sri Lanka. Number one, declaration of colonies. We had, we were colony to Portuguese, Dutch, and the British. And then Royal Charter of Justice, 1801. And then establishment of Supreme Court of Sri Lanka consisted of one principal judge who was the Chief Justice. මේ කාලේ තමයි අපි Supreme Court එක ආරම්භ කරේ. And then clauses of Candian Convention. The religion of Buddha under the British was declared as inviolable, right? අනුලංඝනීය කියන්නේ අවලංගු කළ නොහැකි. And its rights to be maintained and protected. දැන් මතක තියාගන්න මේ බුද්දිසම් කියන එක, බෞද්ධ ආගම කියන එක, ඒකේ අයිතිය ඒකට ප්‍රොමිනන්ට් එකක් දෙන එක ඇවිල්ලා තියෙන්නේ මේ අපේ ආණ්ඩුවේ නිදහසින් පස්සේ නෙමෙයි. නිදහසට ඉස්සෙල්ලා බ්‍රිටිෂ් කොලනි එකේ ඉඳලා. The religion of Buddha was declared as inviolable and its rights to be maintained and protected. බලන්න ඒ කියන්නේ මේක මේ කාගේද සුද්දාගේ කාලේ ඉඳලා තිබිච්චි අයිතියක්. ඒ කියන්නේ රයිට් එකක්. මොන රයිට් එකක්ද? inviolable කියන්නේ violable කියලා කියන්නේ අවලංගු කරනවා කියන්නේ අනුලංඝනීය කියන අදහසයි එකේ එන්නේ. Just one second. Just 1 second. කියන්නේ අපි ඔබට කියන්නේ මම මේ වචනේ හොයන්නේ හරියටම අනුලංඝනීය නැත්නම් උල්ලංඝනය කළ නොහැකි කියන එක inviolable අනුලංඝනීය උල්ලංඝනය කළ නොහැකි අයිතියක්. Okay, right. Subtopic, the constitutional history. You take your note, number 1, 2, and 3.
I'm okay, sir.
I think you have finished.
Yes, sir.
Yes,
Okay, now
sir.
look at constitutional reforms. Right? We had, before independent, Colebrook Commission in 1883. 1933 අපිට තිබ්බා Colebrook Commission කියලා එකක්. එතකොට පාර්ලිමේන්තුවේ, not parliament, but it was called, name of the legislature was Legislative Council. ව්‍යවස්ථාදායක සභාව. ඒකේ members ලා 15ක් හිටියා. ඒ ව්‍යවස්ථාදායක සභාවෙන් තමයි by Legislative Council passes the law in the country. And then we had Macallum reforms, 1910. The name of the legislature, same, Legislative Council. The total number was 21. And then again, first Manning reforms, Manning ආණ්ඩුකාරවරයාගේ reforms, 1920. The name of the legislature, who has passed the legislation, was called Legislative Council. The members was 37. And then we had second Manning reforms, in 1921. The same, the name of the legislature was Legislative Council. The council members, total number of council members was 49. So these councils passed legislation time to time. Do you understand? Is it clear? Is it clear, Sanjay?
Yes, sir. Is it clear?
Okay. Then you take your note or not as it is. මේ රූපරාමයේ තියෙන විදිහටම copy කරගන්න මේක.
Excuse me, sir. Will you able to email this PowerPoint presentation to us, sir?
There will be a YouTube, right, under the LPEC. You check with LPEC. These, the presentation will be there, right, in the YouTube and LMS as well.
Okay, sir. Thank you very much.
If you finish the next
Yes,
one,
sir.
oh, yes, right. Then next one, the same thing. And then we have in 1931 Donomo Commission. Under the Donomo Commission, with regard to passing legislation, the name of the legislature was State Council. රාජ්‍ය මන්ත්‍රණ සභාව කියලා එකක් අහලා තියෙනව ඔයගොල්ලෝ. රාජ්‍ය මන්ත්‍රණ සභාව ආවේ ඩොනෝමෝර් එකේ. Total number of members was 61. And then we had just before 1 year before the independent Salisbury Commission. Under Salisbury Commission, it was Parliament because Parliament was established under the Solberry Commission. We had 131 members. And then 1972, under President Sirma Bandaranaike, first Republic Constitution. Then it was not Parliament, but we call it National State Assembly. Jatika Mantrana Sabha, Rajya Mantrana Sabha. 151ක් හිටියා රාජ්‍ය මන්ත්‍රණ සභාවේ. ඒකෙන් තමයි නීති සම්මත කළේ. මේ අපි නීති සම්මත කරපු හැටි ඉගෙන ගන්න විදිය. Do you understand?
Yes, sir.
Right. මේකත් ලියා ගන්න. ඊළඟ කොටස. ඕකෙම පල්ලෙහාට.
Yes, sir.
Okay, good. Let's others to finish. I hope everybody has finished it. Then we move to main features of the 1978 Constitution. 1978 Constitution. මේකනේ අපි සංශෝධනය කර කර යන්නේ ඉස්සරහට. The basic එක තමයි, base එක තමයි 1978 ශ්‍රී ලංකා ප්‍රජාතාන්ත්‍රික සමාජවාදී ජනරජයේ ව්‍යවස්ථාව. Chapter 1 talks about people, state and sovereignty. Right. මිනිසුන් රාජ්‍ය සහ ස්වෛරීත්වය. Chapter 2 talks about Buddhism, බුද්ධාගම. Chapter 3 talks about fundamental rights, මූලික මිනිස් අයිතිවාසිකම්. Chapter 4 talks about language rights, භාෂා අයිති. Chapter 5 talks about citizenship. Chapter 6 talks about directive principles of the state policy and fundamental duties. රාජ්‍යයේ මූලික මූලධර්ම. ප්‍රතිපත්තිමය මූලධර්ම. සහ මූලික fundamental duties. කාර්යභාරය. Could you please take your note?
Finish, sir.
Okay, what about others? Gabriel, have you done? And the rest as well. Main features, the continuation. Chapter 7, the executive, Vidayaka, Parliamentary Council. And chapter 8, executive, Cabinet of Ministers. And chapter 9, executive, public services. Public service. ඒ කියන්නේ මේ chapter 7 එකේ කතා කරන්නේ පාර්ලිමේන්තුවයි ජනාධිපතිතුමයි ගැන. ඊට පස්සේ executives කියලා chapter 8 එකේ කතා කරන්නේ cabinet of ඒ කියන්නේ cabinet අමාත්‍යවරුන් ගැන. ඒවුන්ට තියෙන බලතල. chapter 9 එකේ කතා කරන්නේ executive public service. ඒ කියන්නේ අමාත්‍යාංශ ලේකම්වරුන් ප්‍රධාන ආයතනවල ප්‍රධාන නිලධාරීන් දිසාපතිලා විශේෂයෙන්ම පරිපාලන සේවයේ නිලධාරීන් සම්බන්ධයෙන් මේකත් ලියා ගන්න.
Okay, sir.
Taraka, you always very quick. Let's others to
Yes,
finish
sir.
it. Madhusa, finish?
Yes, sir.
Okay.
Yes, sir.
Madhu, sir, sorry. And then there are some personal laws. අපි මේවා දීර්ඝ වශයෙන් කතා කරන්න යන්නේ නැහැ. මේවා සම්බන්ධයෙන් ඔබට සාමාන්‍ය දැනීමක්, ප්‍රාමාණික නෙමෙයි. සාමාන්‍ය දැනීමක් ලබා දීම විතරයි අදහස. personal laws ලංකාවේ තියෙනවා. Canadian law. උඩරට නීතිය. තේසවලාමේ law. Right? ඒ කියන්නේ ජප්නාවල තියෙන එක. ඊට පස්සේ මුස්ලිම් law. මේවා personal laws. එකක් ලියා ගන්න. නෑ. මං කන්න මොන හරි ගේන්න කිව්වා ඒ යකා තව දේවල් හරි. දැන් මුස්ලිම් නීතියට අනුව අවුරුදු කීයෙන් කසාද බඳින්න පුළුවන්ද? කීයෙන් පුළුවන්ද?
16.
16. 16. හැබැයි ඒවා කොච්චර ප්‍රායෝගිකද කියන එක ප්‍රශ්නයක්. දැන් මමත් එහෙම තමයි හිතන් හිටියේ. මට 17යි. එයාට 16යි. මමත් බදින් හිතන් හිටියා 17 දී. හරි ගියේ නෑ. හරි. Just joking, huh? Okay. And these are personal laws, ladies and gentlemen. And then there are two main sources of personal law. One is statute and ordinance. මේ personal law ගැන කතා කරනකොට ප්‍රධාන මූලාශ්‍ර දෙකක් තියෙනවා. One is statute. Statute කියන්නේ මේ නීති. හරි ordinance ආච්ඡාපනක්. The other one is case law. Case law කියන්නේ උසාවියෙන් දෙන තීන්දුව. Right? Statute කියලා කියන්නේ ලිඛිත නීතිය. Case law means decided cases from the Supreme Court and the Court of Appeal. Hurry? And then policies relating to personal law have connection with the right property law. Policies relating to personal law have connection with the property law. ලංකාවේ දේපල නීතිය. සිංහලෙන් කියන්නකෝ ලංකාවේ දේපල නීතිය කොහොමද තියෙන්නේ කියලා. නොබෙදූ ඉඩමක් තියෙනවා නම් ඒකේ අයිතිය යන්නේ කොහොමද? දැන් හිතන්නකෝ හස්බන්ඩ් ඉන්නවා. හස්බන්ඩ්ට ඉඩමක් තියෙනවා. නෝ කාටවත් ලියලා නැහැ. අපි සරලව තේරුම් ගමු. So then how that land could be distributed. චින්තක
Wife
To his wife.
half or 50% to the wife or spouse rather. Another 50% to the children, equally distributed. If that man has not married, then
To his siblings,
sorry,
brothers or sisters.
50% to the mother and the father, another 50% to the sisters and brothers. That is the property law in this country. So these personal laws, Canadian law, Desawalami law, Muslim law, these laws associate with the property law in the country. ඔය ඕවා හැදිලා තියෙන්නේ මේ දේපල පිට යනවට හැදිච්ච දේවල්. Okay? We are not going to discuss in detail. So you take your own notes, right? Next one, under this one, right? Personal law. And then first bullet, second bullet, third bullet, and fourth bullet. Take your note.
Sir.
Just wait for 2-3 minutes. Just give me 2-3 minutes. I'm trying to find out another lecture. Where is it? Okay. Right. So, ladies and gentlemen, where is it? This is my last slide. So thank you very much for listening to this presentation. Do you have, I'm trying to move to another presentation. If you have any question in this regard, any question relating to this topic, you have to remember the sources of law and this one. What is that? The constitutional history. That's only. If you have no question, I'm moving to another session. Okay. The topic is, ladies and gentlemen, employment relationship, contract of employment. You don't need to write workman test. Employment relationship, put a dash, contract of employment. Seva niyukti sambandhatave, contract of employment, right? Contract. Seva niyukti givishuma. Before you study labor law or industrial law, you have to understand, because if there is no employer-employee relationship, you can't apply the labor legislation or labor law or industrial law. In order to apply the industrial law, you need to have contract or employer-employee relationship or employment relationship. How do we identify the industrial relationship? So that is what I am going to discuss with you. If there is no employment relationship, we cannot apply the industrial law or labor law. Then how do we identify the employment relationship? I mean the contract of labor, contract of law, contract of employment. So that is what I am going to discuss with you. Is it clear? The idea? Is it clear?
Yes, sir.
Okay.
Yes, sir.
Our topic is employment relationship, put a dash, contract of employment. You don't need to write workman test. It is coming under, it's a subtopic of this one. Employment relationship, contract of employment. Okay, right. So what is the aim of this topic? How do we identify employer-employee relationship or employment relationship? If there is no employer-employee relationship or employment relationship in otherwise or in other terms, we cannot apply the labor legislation. In order to apply labor legislations, there should be an employer-employee relationship or employment relationship. Employment relationship means employer-employee relationship. සේවක සේව්‍ය සම්බන්ධතාවයක් නැත්නම් කම්කරු නීතිය කාර්මික නීතිය බලාත්මක කරන්න ඇප්ලයි කරන්න බෑ. එහෙනම් අපි කොහොමද සේවක සේව්‍ය සම්බන්ධතාවයක් එහෙම නැත්නම් සේවා නියුක්ති සම්බන්ධතාවයක් හඳුනාගන්නේ කොහොමද? Right? That is the main objective of this topic. Right. So what is contract? There must be an offer of contract by one party, an acceptance by the other, some consideration, value to the contract. The contract must be written or oral. Oral means unwritten. Maybe digital also. It is an agreement between two or more parties who are legally entitled to enter into contract. Example, a child, 18 years, less than 18 years, cannot enter into binding contract. The contract sets out the rights and obligations of the parties and terms and conditions of contract. On commercial matters, sales, rental. So let me forget the, you don't need to write the last one. On commercial matters, these are, something relating to commercial matters. But last two, you don't need to write last two. But the others are important. What is contract? Is an agreement between two parties. Okay? There must be an offer of contract by one party and acceptance by other party. When it comes to contract, there should be two elements. One is offer and the other one is acceptance. රස්සාවක් ගන්නකො. කවුරු හරි ජොබ් එකක් ඔෆර් කරනවා. ඒක පිළිගත්තේ නැත්නම් එතන කොන්ත්‍රාත්තුවක් නැහැ. ඒක පිළිගත්තොත් acceptance තමයි කොන්ත්‍රාත්තුවක් ඇති වෙන්නේ. ඒකේ යම් values තියෙනවා. ඒක ලිඛිත වෙන්නත් පුළුවන්, වාචික oral unwritten වෙන්නත් පුළුවන්. ලංකාවේ කම්කරු නීතිය ඇතුලේ රැකියා ගිවිසුමක් ලිඛිතවම තියෙන්න ඕනේ නැහැ. For example, those who are covered by the Wages Board's ordinance, there is no requirement to issue an appointment letter. But under the Sopanopis Act, Employees Act, that is must. Employer must offer or issue a letter of appointment, but not under the Wages Board's ordinance. That is why it is, the contract must be written or oral, maybe digital. So you take your own note. What is contract? Subtopic. And up to don't write the last two bullet forms. Don't write. These are not relevant to the employment contract. That is why I'm not asking you to write it. No, don't write. Don't take your note with regard to last two bullet forms. Okay? Are you getting it?
Yes, sir.
Okay.
Yes, sir.
Sir, I am finished. I have a question. Can I ask now?
I hope you finish.
Yes, sir. I have a question. Can
Yes.
I ask now?
Yes, why not?
Yeah, sir. When we offer letter,
Hmm.
if we are going to take an offer from a foreign country, we say if we are going to
No,
move there.
no, right. No, because foreign country is some other territory covered by some other legislations, right? Legislative territory is different, right? These laws are applicable only within the boundary, within Sri Lanka, right? If you take an
Right.
offer from other country, the other country, the legal entity or legal requirements are different. So we can't address such legal, the requirement being here in Sri Lanka. These laws, labor laws, are applicable only to the Sri Lankan people who are working within the country. Right?
Right.
If you take an offer from abroad,
Yeah.
that is some
Okay.
other legal territory, right? We can't address
Uh-huh.
terms and conditions of employment of other
Okay.
countries right?
Mhm.
According to the Sri Lankan law. It should be addressed
right.
according to their law.
They are laws, right?
Yes, their laws.
Alright.
Very good question. Very good question.
Thank you very much.
Okay. This is the last group that I'm going to deliver my lectures. So if you have any question with regard to labor law raised, I know A to Z. I know A to Z. Some people, yes, Kasun, you raised your hand.
Yeah.
What is?
සර් දැන් ඒ කියන්නේ අපි
Oh,
හිතමු
සිංහලෙන් ඕන භාෂාවකින් දෙමළ හැර.
ඔෆර් ලෙටර් ඒ කියන්නේ ඔෆර් ලෙටර් එකක් හම්බෙලා
ඔව්.
දැන් සාමාන්‍යයෙන් එම්ප්ලොයිමන්ට් මේ ඇග්‍රීමන්ට් ලෙටර් එක නැතුව එයා වර්ක් කරගෙන යනවා නම්
ඔව්.
ඒ කියන්නේ ප්‍රොපර් මේ ඇග්‍රීමන්ට් ලෙටර් එකක් නැතුව
ඔව්.
එතනදී කොහොමද සර් නමුත් EPF ETF ගෙවනවා නම්
මෙහෙමයි. කසුන් very simply ලංකාවේ කම්කරු නීතිය යටතේ කොන්ට්‍රැක්ට් එකක්. ඒ කියන්නේ කොන්ට්‍රැක්ට් කියන එකේ තේරුම සේවක සේව්‍ය සම්බන්ධතාවයක් තියෙන්න ඕන කියන එක. ලේබර් ලෝ එක ඇප්ලයි වෙන්න නම් සේවක සේව්‍ය සම්බන්ධතාවයක් තියෙන්න ඕනේ. ඒක ලිඛිතවම ලංකාවේ නීතියට අනුව තියෙන්න ඕනේ නැහැ. එතකොට ඔබ කියයි දැන් උදාහරණයකට මම කිව්වනේ ලංකාවේ ප්‍රධාන නීති 52ක් තියෙනවා. ඕකේ එන්නේ terms and conditions of employment වලටනේ. ඒ කියන්නේ සේවා නියම සහ කොන්දේසි සම්බන්ධයෙන් තමයි ඕකේ එන්නේ. එතකොට සේවා නියම සහ කොන්දේසි සම්බන්ධයෙන් ලංකාවේ ප්‍රධාන 52ක් තියෙනවා. ප්‍රධාන එකක් තමයි සාප්පු හා කාර්යාල සේවක පනත. ඒ කියන්නේ සාප්පුවක කාර්යාලයක වැඩ කරන අය සම්බන්ධයෙන්. දෙවෙනි එක තමයි wages boards ordinance. ඒ කියන්නේ කර්මාන්ත ශාලාවක ෆැක්ටරියක right වැඩ කරන ඒ කියන්නේ අපි කියනවා මේ blue collar workersලා කියලා කියන්නේ. ඒ අය සම්බන්ධයෙන් තියෙන නීතිමය ප්‍රතිපාදන තියෙන පනත. එතකොට සාප්පු හා කාර්යාල පනතට අනුව නම් appointment letter එකක් දෙන්නම ඕනේ. දුන්නේ නැත්නම් ඒක වරදක්. ඒවා ඔයාලා පස්සේ ඉගෙන ගන්නවා. හරි? ඊට පස්සේ මොකේද මේ wages boards ordinance. ඒ කියන්නේ පඩිපාලක සභා ආඥා පනතට අනුව එහෙම appointment letter එකක් දෙන්නම ඕනේ නැහැ. දැන් එතකොට ප්‍රශ්නයක් තියෙනවනේ. කොහොමද අපි සේවකයෙක්ද නැද්ද කියලා හඳුනගන්නේ කියලා. ඒකට තියෙනවා කවුරු හරි ප්‍රශ්නයක් නැගුවොත් හාම්පුතානේ ප්‍රශ්නයක් නගන්නේ. හාම්පුතානේ කියන්නේ මේ මිනිහා මගේ සේවකයෙක් නෙමෙයි. එතකොට ඒක අඳුනගන්න තියෙනවා control test, integration test, economic reality test, mixed text කියලා ටෙස්ට් වර්ග කීපයක්. ඒවා මේ දේශනයේ අවසානයේ ඔබ ඉගෙන ගන්නවා අද දවසේ නෙවෙයි ඊළඟ දවසේ. හරි. හරිද කසුන්?
හරි සර්.
හරි. මොකද ලංකාවේ නීතියට අනුව appointment letter එකක් දෙන්නම ඕනේ නැහැ. එතකොට appointment letter එකක් නොදීපු තැන්වල කොහොමද සේවකයෙක්ද නැද්ද කියලා හඳුනගන්නේ කියලා විසඳන්න එංගලන්ත නඩු තීන්දුව අනුව තීරණය වෙච්ච ටෙස්ට් වර්ග පරීක්ෂණ වර්ග කීපයක් තියෙනවා. ඒ පරීක්ෂණ වලින් තමයි අපි හඳුනගන්නේ යා සේවකයෙක්ද නැද්ද කියලා. හරි? පැහැදිලිද?
ඔව් සර්. ඔව්. හරි සර්. thank you sir.
හරි. ඊළඟට effect of a contract. කොන්ත්‍රාත්තුවේ සේවා ගිවිසුමේ effect එක බලාත්මක බව. Binding between the parties once it is entered into. ගිවිසුමකට ආවහම එළඹුණාම ඒක oral වෙන්න පුළුවන්, written වෙන්න පුළුවන්. පාර්ශව දෙකක් බැඳිලා ඉන්නවා. එක පාර්ශවයකට විතරක් වෙනස් කරන්න බෑ. Cannot be changed by one party. It contains all the terms and conditions that are agreed to apply to the contract. ඒක ඇතුලේ ඇතුළත් වෙනවා දෙගොල්ල පාර්ශවයේ එකඟ වෙච්චි සේවා නියම සහ කොන්දේසි. No additional provisions can be included by a third party later. පස්සේ තුන්වෙනි පාර්ශවයට ඒකට එක එක දේවල් ඇතුළත් කරන්න බෑ. If a contract is broken, breach of contract. අපි කියනවා breach of contract කියලා. Each party has an equal right to take action against the other. කවුරු හරි එක පාර්ශවයක් වින්දොත් ඒක ඒ අගතියටපත් පාර්ශවයට අනිත් පාර්ශවයට එරෙහිව නීත්‍යානුකූල ක්‍රියාමාර්ග ගන්න පුළුවන් කම්කරු දෙපාර්තමේන්තුව හරහා. So take your note. Effect of a contract, subtopic. Let me know when you finish.
Finish, sir.
Everybody? Kasun,
Yes, sir.
Madhusha,
Yes, I am finished.
Nelunika.
Finish, sir.
Good. Right. Next, parties to a contract of employment. Subtopic. There are two parties. Parties to a contract of employment. සේවා නියුක්ති ගිවිසුමකට සම්බන්ධ පාර්ශවයන් කවුද? Parties to a contract of employment. We are not talking about other contract. We are just talking about employment contract. There are two parties. One is the employer. The second one is the employee. Employer can be a company. දැන් මෙන්න මේක කියනකොට මම සිංහලෙන්ම කියන්නම්. කෙටි සටහන් ලියන්න දුන්නාම employer employee කියලා කට්ටිය ලියනවා මේක. Can be a company represented by authorized person such as director, CEO, manager. ඔහොම ලියනවා. ඕක නෙමෙයි එතන ලියන්න තියෙන්නේ. අපි industrial dispute act එක කතා කරනකොට ඊළඟ මාතෘකාව ඊළඟ දවසේ මේක ඉවරනාට පස්සේ කතා කරනවා industrial dispute act එක ගැන. ඒ කියන්නේ කාර්මික නීතියේ ප්‍රධානතම එක. ඒකේ තියෙනවා employer කියන්නේ කවුද? worker කියන්නේ කවුද? නැත්නම් employee කියන්නේ කවුද කියලා definition. ඒ definition එක තමයි උත්තරේට ලියන්න ඕනේ. නැතුව මේකේ තියෙනව නෙමෙයි. මේක තියෙන in general. Right? Okay. Parties to a contract of employment. Just we are not defining it. We are not defining who is an employer and who is an employee. But we are just talking about the parties. There are two parties. Parties to a contract of employment. One party is the employer. Employer can be a company represented by an authorized person such as director, CEO, manager, executive, etc. Employee, also called workman or worker, must enter into a contract personally. A third party cannot sign on behalf of the employee. එයාම contract ගිවිසුමට එකඟ වෙන්න ඕනේ. agreement ඕනේ. Employee must perform his duties personally, cannot substitute someone else unless the employer agrees specifically. ඒ කියන්නේ employee කියන එක්කෙනා තමාගේ duty එක තමාම කරන්න ඕනේ. වෙන කාටවත් ඒක දෙන්න බෑ. Okay? Right. Take your note. Subtopic parties to contract of employment. And then employer and employee. Take your own note. I mean, by yourself. Did you finish?
Yes, sir.
Yes, sir.
Okay. Now, remember that in Sri Lanka, contract of employment should not and no need not to be have in writing. It may be oral, implied, express. So that is what this slide talks about. Special characteristics of employment contracts in Sri Lanka. This is very, very important, ladies and gentlemen. A contract can be written oral, written or unwritten. Unwritten mean oral. Sometimes a contract may be created between the parties unknowingly, නොදැනුවත්වම, depending on the actual relationship. It contains only some of the terms between parties. දැන් සේවා ගිවිසුමේ හැමදේම නෑ. පොඩි දෙයක් විතරක් තියෙන්න පුළුවන්. හැබැයි ඔබ දන්නවද? කම්කරු නීතියෙන් කම්කරුවෙකුට හිමි කරලා දීලා තියෙන දේවල් සේවා ගිවිසුමේ තිබ්බත් නැතත් ඔටෝමැටිකලි සේවා ගිවිසුමේ කොන්දේසි බවට පත් වෙනවා කියලා ඔබ දන්නවද? Even though all terms and conditions have not been stipulated or cited in the contract of employment, the rights that have been granted by the labor law becomes implied terms and conditions of contract of employment. Okay? So it contains some of the terms between parties. Other terms may be added into the contract by labor and employment law, superior court decisions, Supreme Court and Court of Appeal, collective agreement, and custom of practices. So you take your note, ladies and gentlemen, and raise any questions if you have. Hello, did you finish?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
I have a question.
Yes, yes, you can raise any question.
Sir, when it's going as that means mutual understanding, the contract, we say like it is verbal, then unwritten. You said previously that if we have a mutual understanding, mutual contact between the employer and the employee,
Yes,
we'll say it is coming as a verbal contract. If the employee has done something, how can the employer get an action against him?
you know, the connection is not very clear, but as I understood, let me tell you, there is no written contract, right? It is understanding
Hello.
between employer and employer and employee. That is what you are saying, right? So no worry about that, right? There are many methods to check whether there is an employer-employee relationship or contract of
Okay.
employment.
Okay.
In dispute,
Yeah.
let me think. In dispute arises. In dispute arises. In the case of dispute arises. Right? The question you raise arises if there is a dispute. If there is a dispute, right? Okay, right. Then I didn't understand
Yeah.
the second part of the question, right?
Yeah.
Could you please explain it?
Yeah. That's right, sir. That's right. That's what I want to know.
Okay. Because, if there is a dispute
Yeah, that means
arises, even
if
though,
a dispute has happened, previously that.
if there is a dispute arises, right, we have many methods. Because, first you need to understand, in order to apply labor law, there should be and must be employer-employee relationship or contract of employment. Contract of employment is the relationship between employer and employee. In Sri Lanka, it should not be, employment, contract of employment or employment relationship should not be in writing. It may be oral, implied, explicit, right? Implicit, whatever it is. But if there is a dispute arises, then we have many methods to check whether there was an employer and employee relationship. Then if we find out whether there is an employer-employee relationship, we will apply the labor law. Okay? It takes many, it takes a couple of, significant time for you to understand. When you study other legislations, then you will understand, how it could be applied. For the moment, what I can say is contract of employment or employer-employee relationship. Contract of employment is nothing but the employer-employee relationship. It should be a written means appointment letter. It should be oral, no appointment letter. But then, if dispute arises, we will check whether that person is an employee or worker or not. Right? So, based on that information, we will apply, in the sense, the labor department applies us the labor legislation. Is it clear?
Yes.
Okay. Special characteristics of employment contract in Sri Lanka. Did you take your note or not?
I have taken my notes. Yes.
In relation to this one?
Yes, sir.
What about others? Somali? This na? Ayyo. Madhusa? Madhusa.
Yes, sir, we have taken our notes.
Okay. Next. I'm not going to discuss. Almost we have completed 2 hours. So next topic is contract of employment versus මෙන්න මෙතන තමයි අපි හඳුර ගන්න ඕන දැන. Contract of employment versus contract for employment. මේ දෙකේ වෙනස හඳුර ගත්තොත්. Contract of employment සේවා නියුක්ති ගිවිසුම සහ සේවා නියුක්තියක් සඳහා වන ගිවිසුම. සේවා නියුක්ති ගිවිසුම සහ එරෙහිව සේවා නියුක්තියක් සඳහා වන ගිවිසුම. සේවයක් සඳහා වන ගිවිසුම. එතකොට මේකේ contract of employment, there is an employer-employee relationship. But when it comes to contract for employment, there is no employer-employee relationship. It is master principal or master worker or principal agent, right? Or master worker relationship. With regard to contract for employment, we cannot apply labor law. This is independent contract. But contract for employment, yes, there is an employer-employee relationship. We will learn it the next day, right? You have to remind me that I'm not taking my note. You have to remind me that we have to start from slide number 6. Okay? Do you understand?
Yes, sir.
Yes, sir.
The assignment, the task is given to Madhusa. Madhusa, you have to tell me that when I'm, starting next lecture, you have to say that, okay, we discuss about what is the topic, contract of employment, or yes, employment relationship. We have to start from slide number 6. Okay?
Okay, sir.
Right. So, good night for everyone. I hope you understood what I said so far. Am I correct or not?
Yes, sir. Yes, we have understood.
Okay.
Thank you very much, sir.
Thank you, sir.
Good night.
sir.
Good
night
night,
for
sir.
everyone.
Good night, sir.
Thank you, sir.
Good night.